We're going to go over objections to discovery. So when somebody sends you discovery, you can object to it. And we're just going to talk about the objections here, and then in the next course we'll show how to answer them specifically. So, one objection is relevance. A party may object to discovery if they believe it's not relevant to the case. So relevance is a pretty wide one. So, like whether or not you're a criminal can be relevant to a family law case or to a breach of contract case, because they could be bringing it up for the purpose of, are you truthful? If you've got a bunch of hot checks, and they'll say that you're deceitful, and they'll use it to attack your honesty. Stuff like that. So there is ways it can be relevant, but, if it's a breach of contract case and they're talking about your mistress, not really relevant. So you can object for those reasons. It can be overly broad or unduly burdensome. So if somebody sends you a discovery request that's like, give me all the documents you have, period, then you can object to that. Or if they say, give me every check you've written in the last 20 years, same objection. Privileged information, and you can see the list of the privilege here. This is just, there are privileged things that are privileged between people. Could be doctor-patient, could be client, could be spousal. Now, that say, if you have brought some sort of action, you can move away from that privilege. For instance, if you're suing your doctor for malpractice, there is no doctor-patient privilege. If you're suing your lawyer for malpractice, there is no attorney-client privilege, because the suit itself involves those records and they're necessary, so the privilege gets waived. The work product doctrine. So this is about if you're doing something to prepare for litigation. So that'd be typically that's in the context of between you and a lawyer. You can also object for privacy reasons. Typically this is going to come in more of a relevancy thing, but it's that trade secrets of confidential information, vague, ambiguous, or this is about when you're just not sure what they're saying, so you want them to give you a more specific request. This one happens sometimes. You can for legal conclusions. So if somebody makes discovery is for facts, not conclusions, right? So to make that make sense, let's do a request for admission. If you say, please admit you stabbed so-and-so, you're going for a fact. If you say, please admit you committed battery, that's a legal conclusion, if that makes sense. So you're requesting facts. So make sure that your questions are to pull facts from the other party, not to draw conclusions. Or if you've already given them something and they keep asking you for it, you can object for those reasons. Those are the main reasons that objections are allowed in discovery. We'll have some information below this, links to other resources, but those are the main things for you to look at. And in the next lesson, we'll talk about how to actually put the objection into the discovery. Thank you.